number 37, the people of the state of New York versus William Morrison. Good afternoon, counsel.
Good afternoon. May it please the court, Hannah Stith-Long for the people. May I please reserve 1 minute for rebuttal?
Yes, you may.
No mode of proceedings error occurred here for two independent reasons. First, the note in question contained a ministerial recess inquiry not subject to ORAMA. Second, the court gave notice of the specific contents of the note by giving counsel reason and opportunity to inspect the note herself.
Isn't there a possible ambiguity in the note? Certainly it can be seen as ministerial, and we know the background, but if there's any question whatsoever that maybe they were asking for something more than just, can we go home and come back the next day, isn't it essential that counsel have an opportunity to see that and make their argument?
If there were a reasonable view of this note, that it were a substantive request, that would be the case, but there is none. The court in this case...
Well, let's say we disagree with you on that and get to the next stage, whether or not the court's dealing with a note is adequate.
Yes, if this note were deemed substantive, the record here, even the existing incomplete record, shows meaningful notice.
Well, let me tell you what my problem is with that, and then you can respond to it. It seems that the court here made a conscious decision not to read jury note 9 into the record because the court was concerned that there was media present in the courtroom and that it would somehow affect jury deliberations by reading the note into the record in open court. So the court not only didn't read the note, but the court made a record of making a conscious decision not to read the note. Would you agree with that? Is that
Yes.
what happened here? So do you think that fulfills the requirements of meaningful notice that are set out in the ORAMA and its progeny?
That alone does not, but what the court did was to alert counsel that the note was available as a court exhibit.
Well, we're into the same thing we were talking about before, and I'm having a difficult time seeing how it's the court's obligation to provide notice on the record. If it's not on the record, then we can't review that notice. It appears to have been clearly, consciously even, decided not to be provided here.
Well, the lodestar of this court's ORAMA jurisprudence has always been the effective assistance of counsel, not whether the note was read or shown, but rather whether the court's notice procedure gave counsel the information that she needed to participate effectively in the court's response. ORAMA itself teaches that no mode of proceedings error occurs where procedures equally conducive to counsel's participation are employed.
Isn't that confusing, the meaningful notice with the meaningful response? It seems to me that's where we've sort of taken a fork in that road. And we said, one has to be exact. It has to be on the record. This is what the court has to do. The other, okay, well, you may have to preserve it. But what we're talking about here is the meaningful notice, not the meaningful response.
We are not challenging meaningful notice. We believe there must be meaningful notice and that counsel should have notice of the exact contents. But that notice can be accomplished by giving counsel reason and opportunity to inspect the note herself, which the court did here. And neither the record in this case shows, nor does defense counsel even claim that there was any impairment of counsel's effectiveness.
Well, that's not what they have to do if there's a mode of proceeding error. What they have to do is you have to show that you gave them notice on the record.
This court does not recognize mode of proceedings errors that do not involve either the impairment of some fundamental constitutional right or a lack of jurisdiction on the part of the court. And that's a longstanding principle throughout this court's mode of proceedings jurisprudence, and including in the note of jury note cases, Where the court has found a mode of proceedings error, there was some kind of impairment. Like in Kissoon and Walston, the court left out a material part of the note while purporting to read it verbatim. In Silva and Hansen, the court didn't reveal the existence of the note. Those things impaired counsel's effective assistance, and therefore there was a mode of proceedings error. Here, there was no impairment whatsoever of counsel's effectiveness. Counsel could easily have looked at the note if she had not already. If actual knowledge were if the record were required to show counsel's actual knowledge of the contents of the note, counsel could create a mode of proceedings error by simply refusing to look at the note. Because mode of proceedings errors are unwaivable, reversal would be required.
So your rule is that marking the exhibit as a court exhibit provides sufficient notice under ORAMA?
If counsel doesn't realize it's been marked as a court exhibit, that might not be the case. And if counsel doesn't realize that the court is not going to read the note, that might not be the case. But the rule we're seeking here is that where the court's procedure enables counsel to participate effectively, in other words, where the court's procedure is clear and gives counsel reason and opportunity to inspect the note herself and learn the contents of that note, no mode of proceedings error occurs.
Well, here, let me ask this. If you're asking for notice, you're saying that there was notice, but aren't you also saying if there wasn't sufficient notice that we should order a reconstruction hearing?
Absolutely.
So you heard our discussion before in the case before you. And basically the same question I wanted to ask you. What rule would you say that we should apply in determining when to order a reconstruction hearing in this context?
Well, the court laid out a rule in Velasquez, and that is where it's clear an off-the-record proceeding occurred or there's significant ambiguity in the record. There doesn't have to be a whole lot of proof that an off-the-record proceeding occurred. For example, in Cruz, there was a reconstruction hearing where it was unclear whether there was notice of the jury note or not. In Odiot, it looked like the defendant actually wasn't present for a Sandoval hearing, and this court remanded for reconstruction. In Santorelli, there was no antimarchy waiver. It was remitted for reconstruction. So there doesn't have to be a lot of proof, but there has to be some indication that a material proceeding occurred that was not transcribed. At least some ambiguity in the record. And
But I don't see the ambiguity here. Here the court clearly said, I'm not going to read the note into the record.
But there's a constellation of different factors that indicate there was a discussion beforehand. And one of those is that in the court's response, the court expressed the preference of the attorneys as well as its own preference that the jury continue deliberating. The court could not have known that preference of the attorneys without having had a discussion with the attorneys beforehand. Continuing on the reconstruction point, a breach of the affirmative duty to create a contemporaneous record cannot itself be a mode of proceedings error. It does not impair any constitutional right except for the right to appeal, and then only if reconstruction is impossible. As the court said in Rivera, valid trials have been held and appeals have been justly determined long before the advent of modern stenography. It is the court's duty, the trial court's duty, as the final arbiter of the record, to labor to elucidate what originally occurred before the court. And this duty dovetails with the principle that this court set forth in McLean and Kinchin and prior cases, that an appellate court will not reverse on a record that does not conclusively show reversible error. If it were otherwise, it would be the ultimate opportunity for gamesmanship. What counsel would object when the court is failing to make a record of ORAMA compliance, when counsel knows there would be a free automatic reversal?
Once again, that's not what we have here. There wasn't gamesmanship. The court made a conscious decision not to read the note into the record.
Yes, and the court may have showed it to counsel before that.
Well, you're saying that,
confident
but
that
there's no record that substantiates that speculation.
Well, does the record show that the court made a conscious decision not to show the note to counsel, or does it a conscious decision not to read the note in the public courtroom?
Absolutely, Your Honor. It shows a conscious decision not to reveal the partial verdict. It does not show a conscious decision not to share it with counsel. We are confident that a reconstruction hearing would show that the court handed it to counsel.
So the sufficient evidence in this record that perhaps defense counsel, had they not seen the note, had enough here to say, Judge, can I just see that, what you've just marked? Or, I mean, there's no fair reading of this record at this point that he was trying to hide the partial verdict from the defendant or the prosecution? Is there?
No, absolutely not. Counsel had all the information she needed to say, Your Honor, hold on a second, may I please see the note before you proceed? If she hadn't seen it already, we believe she actually had seen it already, but if she hadn't, she could easily have objected at that point.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, good afternoon. Mary Humphrey for defendant appellant William Morrison. There was absolutely a mode of proceeding error here. The record clearly shows that. The judge undisputably said, I have Court Exhibit 9 here, and I will not read that into the record. And there was no indication that there was any off-the-record discussions where either counsel were showed that particular jury note.
But there are indications, strong indications, that there were off-the-record discussions with respect to other jury notes.
Other jury notes, but not 8 or 9, Your Honor. The record does not indicate that there were any prior off-the-record discussions regarding specifically Court Exhibit 9.
So it's okay then for the lawyer to hear the judge say, I have this note and I'm not showing it to you, and the lawyer doesn't have to do anything in response to that? Just hold it in their back pocket and raise it when it gets here?
That's
Or
the
to
law.
the appellate division?
It-
But that wasn't the decision in Cadarco, right? In Cadarco, the judge says, I'm reading this note, and I think it was pretty clear in Cadarco they didn't have the note, but I'm reading this note, it's public, I'm not reading the split, I'm not telling you the split. And we said in Cadarco, even though that was a notice issue, once you knew the judge wasn't going to comply, you had an obligation to object. So why is that different than, I'm not reading this note? You know the judge isn't complying at that point. And why is that different than Cadarco?
It's a mode of proceeding error. It's not in compliance with ORAMA or.
But Cadarco technically wasn't in compliance with ORAMA either, and the argument was it was a mode of proceedings error, but we rejected that argument, saying that when you knew the judge wasn't complying, I am not telling you this, I am not reading this into the record, you had an obligation to object at that point.
I feel that she was not under other case law, ORAMA, CP 31030, that she was not obligated to object because it was a mode of proceedings error. I understand your question, but I disagree that she was under any obligation to object at that point.
Do you have anything to say about whether or not this was ministerial when you were looking in the context of the whole situation with the snowstorms and the whole context from the whole transcript? Why wouldn't we be justified in just saying, you know what, this whole business was ministerial, and therefore it's not a mode of proceedings error?
Because as the majority of the Fourth Department points out, it is ambiguous. The dissenting judge in the Fourth Department decision does make a good case for why it's ministerial, but that's only speculative, and it can only be.
What is the ambiguity? I wasn't really clear from the majority's writing what they were articulating was the ambiguity. All they say is, well, you could read it that way. But of course, there's speculation about what you can and can't read. What's the ambiguity?
Basically, not sure what to do was the ambiguity. And the majority said that's a clear question or a clear request for direction, which I believe it is, not sure what to do.
But
And
in context, couldn't that be about not sure what to do to keep going or not going, as opposed to about a substantive material issue?
Especially when right before the not sure what to do, the sentence before is, I don't see it being quick, meaning a verdict.
And if I may, this problem had come up over a couple of days. What do we do as we're getting closer to the end of the day?
Right, I understand. But they had previously specifically asked when they wanted to leave early and start the next day, they specifically asked that. I think if they wanted that specifically, they would have asked for it. They didn't ask for it in this note, so they didn't know what the other options were, so they're asking for direction.
I had thought that they said that, I'm not sure what to do. We've reached a verdict on 1 and 2. It may take a while on 3, or something like that. that's the way I read the ambiguity. And part of it was, it seemed to be information that any attorney's going to want to know, which is that the jury indicates they've reached a verdict on some counts. And that information was not given to the attorney. And part of it was, how long should we keep deliberating? I thought that's the way I read the Fourth Department's decision.
I think it's ambiguous, as the majority
That's
points
my
out.
point. Yes.
And I think it could possibly have been related to, should we continue, should we stop and start? But we will never know that. We can only speculate that they possibly were asking, should we stop now, or should we resume tomorrow morning? I think that, as the Fourth Department points out, the majority decision, that the ambiguity has to be decided in favor of the defendant.
Well, the way I read it is that a defense attorney always has a right to know if a jury's saying, oh, we've reached a verdict on some of the accounts, but not the other counts.
Right, but we have no indication that the defense counsel actually saw that note.
That's the point. That's why we have ORAMA,
Right,
so they would know that.
right.
Right.
And that was our mode of proceeding error.
Yes, ma'am.
Counsel also referred to the judge saying that clearly there's an indication that the judge had discussed the notes with attorneys, because he said, we want you to continue deliberations. Well, of course, the attorneys want the jury to continue deliberations, whether it was further on that day or tomorrow morning. That is not an indication that the substance of those notes were discussed with counsel, with defense counsel or either counsel.
If we were to hold that reconstruction hearings are appropriate in certain instances, why would a reconstruction hearing be inappropriate as a remedy in this particular case?
Because of the major reason is because of the passage of time. These proceedings took place in March of 2007. That was over 11 years ago. There was a case that I spoke of in my brief where a reconstruction hearing was ordered, and 4 years later, no one, the judge, neither attorney or the court reporter, could remember anything about that particular jury note.
So instead, we should reverse and send back for a new trial completely with the 11-year-old evidence.
Right. I think a reconstruction hearing would have to go back with instructions as to what should happen on each contingency. If they go back and depending on who says what, then we need further instructions on where the case would land up. Whether we start with an appeal de novo, do we come back to this court, does it go back to the Fourth Department? There were too many contingencies that would need to be provided for if a reconstruction hearing was ordered.
Thank you, counsel.
Thank you.
Counsel?
Counsel, one problem I have with this ministerial argument the government is making is, I understand the response to the note, it was something of an Allen charge, indicating that, to me, the judge thought this meant we're deadlocked.
Actually, the court had given Allen-type instructions long before jury deliberations began. And in this particular
In the
instance,
spirit of optimism.
well, the court had 1 week to complete this trial. It was the court's third attempt to bring the defendant to trial. And this jury note came back on Thursday
To
night.
conduct the trial, you brought him to trial, but you meaning the people.
Yes.
Okay.
I'm sorry, Your Honor, yes. And this was Thursday night. There was 1 day remaining available, and there was snow and sleet predicted overnight that threatened the feasibility of deliberations that day. None of the jurors had been vetted for Monday availability, and the alternates had, at this point, had been
Well, why
dismissed.
wouldn't it have made more sense to actually make sure that the lawyers have seen the note, particularly given that, and take a partial verdict? Well, maybe that's what defense counsel would have done if the record reflected that they actually had seen the note and they could say, Judge, let's take because I think it said, we have arrived a decision, that's the note, on 2 and 3, but we have a lot of work to do on number 1. I don't see it being quick, not sure what to do. We are starting to make way. All right? If the defense lawyer had seen that, they may have, or the prosecution may have asked, Judge, take a partial verdict so that if we do end up in this weather, we at least have that verdict, and then you can declare a mistrial on the third count.
Well, we believe the defense counsel actually had seen it, but in any case, the defense counsel could easily have asked, hey, can I see the note? Interestingly, in Cadarco, the court ruled that defense counsel could have objected either before the note was fully disclosed or afterward. So because the court's procedure was made clear on the record, as it was here, counsel could have objected before the note was fully disclosed. And also, ultimately, in Cadarco, the note was fully disclosed by the court saying, at this time, I'll show the parties the last note, whereupon the note was marked as a court exhibit. Very similar to what happened here. The same ability for counsel to learn the contents of the note and object effectively. In sum, because ministerial matters, ORAMA departures that do not affect the participation of counsel, and omissions in contemporaneous record-making do not affect the mode of proceedings, the appellate division's order should be reversed.
Thank you, counsel.
Thank you.